excessive and unreasonable by the William law, right?
Right.
Okay.
Yeah, I'm going to give you a copy of Exhibits 1, 2, and 3 to refer to. I'd ask you first to refer to Exhibit number 1, sir. Could you please confirm to the jury that as your signature on page 3 of Exhibit 1?
It's not. But we can move on.
It's not your signature.
100% it's not.
Whose is it?
You got me. I only have about 1,000 signatures over there. Match this one up with one of them.
So someone signed this document and forged your name to it in August of 2007.
I've never seen this document. And I guarantee you, you can't pull a signature that I've done, any one out of 1,000 that looks even close to that.
Would you look at page number 1 or Exhibit 1, please, sir?
Page 1. Yeah.
This is a letter dated July 18, 2007 from Kenny Ross, addressed to you as personal and confidential at 69 Conway Grove Road in Gary. Is that what it says?
Does say that.
Is that your address? Was that your address in 2007?
It's still my address.
Did you receive this letter?
No. Not that I recall. And listen, you see that signature? You've got my signature on 1,000. Tell me if it's close. Yeah,
We
it's
had a
good.
sidebar conference with Mr. Gilbert here as well.
Well, the last question was, he had not seen the document before, he said he never received it. Yeah, I did, yeah.
I was going back.
Would you like a copy of my driver's license, Mr. Hilliard, so you can match up the signature to find out we're not even in the right ballpark?
So, Mr. Gilbert, is your testimony under oath that you did not receive the July 18, 2007 letter?
What I'm saying is, what you just showed me here, I've never signed. And the signature you're showing here, which could be clear to all the jurors, if you'd like to do multiple copies of my signature to see if this is my signature.
Did you receive the letter?
I have no memory of this letter, and I'm telling you, that is a forgery. In fact, let me take a look. Just checking the signatures of the people who did sign it, because it looks like they used the same pen. And if you would have mailed it to me, then I wouldn't have it signed yet, would I? Would you like a copy of my driver's license to verify the signature?
I just want to confirm that you're denying under oath before this jury.
Under oath, I'm telling you, this is a forgery, flat out.
And you also deny receiving the letter.
Right, that I have any recall of receiving this. This would have been 7 years ago. But I'm telling you this, I did not sign this. So this fee agreement, so forth, is a forgery. Look at the, you know what, my business is checking forgeries. I run a mortgage company. And you know something? Take a look at the pen who wrote it and the pen there.
It's not your signature.
I think I made that clear, haven't
It was
I?
not signed on your behalf by...
Excuse me?
It was not signed on your
Absolutely
behalf
not. Why would I? Doesn't it say they witnessed it?
The letter says, at the bottom, read, approved, and accepted. And there's a line for signature by Michael J. Gell, and the date.
Pretty clear to me, and that's not my signature.
Let me ask you what you exhibit 2 for a moment.
We all down with one?
For a moment. Exhibit 2. Mr. Gill, and I'm focused on page number 4. In the lower right-hand corner of page number 4. And the entry of July 30, 2007. See that one?
Yes?
It's an entry by DSS, which is Attorney Sedgwick, conference with Michael Gill and Attorney Ross.
I remember it clearly.
So you did attend a meeting with Attorneys Ross and Sedgwick on July 30, 2007. Is that
Wrong. I want to explain it to you. I met with Mrs. Ross. We were in a conference room with all glass. Mr. Ross came by, knocked on the window, and called her out. The door opened, it didn't close quite, and what Mr. Ross said to her, don't get close, you know what we have to do. When she came back in, that was the beginning of me putting me very curious about what's going on. So it was that meaning exactly. Miss Sedgwick testified to that.
Objection, we'll start the last portion of the answer. But, Mr. Gill, please also refer to page number 2. Again, Exhibit 2, which is the invoices.
Can you speak up again, Mr. Hill?
I'm sorry. Please refer to page number 2 within Exhibit 2, which is the invoices.
Right. So number 2 is the last month. It really wasn't that month. It just billed me for sending me the bill, which extended the bill process. But go ahead.
There's an entry on July 30, 2007 by LJR, which would be Mr. Ross, 1 hour conference with client. Do you see that?
Conference for client. Yeah. Never happened.
Never.
I remember clearly. Do you remember, Mr. Ross?
Your Honor.
Now you're in the position of having to answer the question I asked you.
And the document we have is Exhibit 1, at least purports to have a signature by you on August 2, 2007, 3 days after July 30, 2007. Isn't that right?
What date are we looking at?
I'm comparing the entries in the bills.
I understand what you're doing. What
Saying
date?
that there were conferences with you by Attorney Ross and Attorney Sedgwick on July 30, 2007.
We didn't have that. I testified to that. Mr. Ross and I spoke all of about less than an hour the whole time.
3 days later, we have someone forging your signature to the engagement letter on August 2, 2007. Is that right, Mr. Gill?
Absolutely right. And I would like, Your Honor, to present as evidence number of examples of my signatures.
You have to just answer the question.
Well, I am asking the question. I've asked it 10 times, the same thing. So it's not my signature, but I think it's important now to show evidence, we wanted to see evidence, that this isn't my signature, not even close.
Sir, you're a fact witness now. You just answer the question. You can't editorialize it.
I know, I'm about to
In
be
your
a lawyer, I'm a
closing-
witness.
in your closing statement, you can't. Okay, but now.
If you're looking at page 2, please, of the invoices, Exhibit 2, it reflects that on July 31, Attorney Ross prepared and filed an appearance on your behalf in the divorce case. Correct?
I do see that.
And you received a copy of that appearance from Attorney Ross in the mail when it was filed with the court, correct?
I don't recall. I don't know that.
Did you ever receive any copies from Wigan and Norrie of letters or pleadings or orders that were filed or received in your case?
Well, you have copies too. All I'm saying is the one that I saw, I didn't sign. Now, preparation for Attorney Ross' appearance, did I get that in the mail? Letter? Maybe. I'm not disputing a letter from 7 years ago. I'm telling you I didn't sign that agreement.
Attorney Ross testified here this afternoon that it was the practice of his firm in 2007 and 2008 to send a copy to the client of anything that went out or came in on on the client's case. My question to you, sir, is did you receive from William and Lori on a regular basis copies of anything they filed on your behalf with the court or received from others on your behalf of the court or others?
Did I get mail and motions and so forth? I did. I'm not a lawyer, and I did get a lot of that in the mail. And I'm not saying work wasn't done, just not on my behalf. And I'm telling you that Mrs. Ross' signature here and my signature here is the same pen, and I didn't sign it. So where did that leave us?
Mr. Gill, looking now at Exhibit 2, I take it that you agree that you received monthly bills from William and Lori during the time that firm was represented. Is that correct?
It was, and I stopped sending them with Dallas Sedgwick saying that Mr. Ross said, make it rain, and it was fraud to get through the statute of limitations, and that's when I stopped paying.
So the first piece, he got the bills on a monthly basis.
And in fact, Mr. Gill, these bills are under tab 2 or Exhibit 2. These bills each month contain an itemization of the date, the activity, and the person who performed it, and the amount of time. Is that right?
Yes.
Did you review these bills when you received them?
No.
I take it then that you didn't review them, you didn't raise any questions or concerns about the activity or the time and the amount of the bill. Is that correct?
The amount of the bills I thought was excessive. Hundreds of thousands to get the board that turned out to $5 million, I thought was excessive. But what got me upset was when I found from Attorney Sedgwick that it was all fraud, and that he was bringing in his friend in to play catch.
Move to strike the last part of the
Right.
next one.
He didn't question.
And in fact, you paid, did you not, Mr. Gill, the August, September, October, November, December, January, February, March bills. Is that right?
Right, until I found out what Mrs. Sedgwick told me. And then I immediately moved Alice Watcher for a malpractice case and into Boston for a malpractice case against Mr. Ross, and then terminated him.
So the answer, folks, is yes. Right, next.
You received the bill for the work that William and Lori did on your behalf in April of 2008, sometime in the earlier middle of May. Is that right?
I don't recall that, but I got a bill every month. It was
And the bill for May, excuse me, the bill in May for time in April is on page 79 of our materials.
Your question?
You never paid that bill, did you?
Well, if you notice, that's the month that I found out. Miss Sedgwick told me what he was doing. She even also said, and put it under oath, that, or under a statement, that it was all fabricated. All the bill was.
So the answer, sir, is you didn't pay the bill, right?
Right, that's why.
Okay.
I paid every other bill on time, my whole life.
Disregard anything else but the answer to your question.
Your testimony in the road that you paid every bill your whole life, except these two?
Oh, and Divine Middle Match when I caught them. But outside of that, I pay all my bills on time.
What about the law firm of 10 and 10 that you hired after you fired William and Lori?
Right, and Divine. You were right, I filed them. And, just like you said, brought them into court. Listen, when we started playing catch with Mr. Ross, they brought in Mr. 10.
And what about the McLean law firm that you brought in?
I want to talk about the law firms, let's talk about those lawsuits, and then I get to talk about them.
You made a statement, you always pay your bill.
I do.
You didn't pay?
I don't owe, I don't pay on fraud and cheating. In fact, I own a mortgage company. It has to be impeccable. So the question should be, why now? Why then?
Is at least...
How about this? I did get to pay $5 million.
Is at least 4 law firms that you didn't pay their bills? Is that
10 and 10, Divine, maybe Morris Mahoney, all of which we're suing, all of which offered me $40 million to settle, including him.
Disregard all that. He can only give you fact evidence, not suppositions.
It was Hilliard that brought this up, not me. He opened that door. I didn't sign anything with anybody regarding to keep my mouth shut about mediations. I'm telling you, including his own client, they offered me settlement offers, and you can see it in writing. Well, I have it in writing. Is that a fact?
No.
Your Honor, I got to disagree.
Come on, sir.
Your Honor,
He brought up these lawsuits. He brought up the law. I do my bills was fraud. That's why. So he needed an explanation. He trying to set up down line. I'm trying to tell him that I'm not. He's trying to create something that doesn't exist. You brought up the law firms.
Your Honor, I approached the bench for the sole reason that the last thing he said was someone had made an offer of settlement, and he pointed
for an explanation.
And he pointed to Mr. Ross as if to suggest that that is.
Don't tell anybody. It's on the internet. You can check it out.
Your Honor, I will represent to the court there has been no discussion with this gentleman on behalf of William and Norrie about paying a nickel.
Mr. Hilliard just lied to the court. Not a nickel, huh? You're right. It was a lot more than a nickel.
Settlement, and
I have it in writing. You better know I have it in writing. It's in your ears, part of the settlement. Part of the settlement. That's the right issue you have, though?
That's what I came for to at some point, Your Honor.
Bring it in. I'll bring it in.
The process, I know we have an intelligent, sophisticated, experienced jury, but at some point, the process gets so tainted.
You're right, at some point. I'm not sure where they are, but we may be close.
Thank you.
Ladies and gentlemen, the law in this state is that with respect to settlements or discussions about settlement, they're not admissible for evidence for juries to hear. You're here to hear the facts, in fact, what these parties may or may not have discussed amongst themselves before they got here and decided to put their case before you to decide. That's all irrelevant.
But if it's in writing, Your Honor, on the internet, from them, is that
disregard? Next question.
Your Honor, I'm just checking out things you've already covered. One final thing, Mr. Gill, you fired William Norrie in May of 2008, is that correct?
I don't know. Your bill says you're charging me from June or August. So I'm not sure. Is that the end of May?
It's the end of May 2008, sir.
Okay. So yes, I did fire them.
And your divorce case was finally scheduled for trial in March of 2012, is that right?
They settled the night before they went to go to the trial.
In March
For a tenth of what I offered my wife.
Your Honor,
They settled that before they went to bed.
in March of 2012, correct?
Right.
Thank you, sir.
I learned that Steve Tober would be adverse counsel. I knew Tober as he represented Wiggin and Norrie and had even represented me personally on a sensitive matter. I also knew that Tober was very close to Ross, that the two were good friends, and that Tober had previously represented Ross. From the time Tober first appeared in the case, his litigation tactics were extremely aggressive. Tober took a scorched earth approach, Tober's approach would be to excessively bill the divorce case, all of which would unnecessarily lead to increased legal fees for Gil and depletion of the marital estate. Eventually, it would become clear to me that the goal of Ross and Tober collectively was to extract considerable legal fees out of a once sizable marital estate. In December 2007, Gil became uneasy with Ross as his attorney. I recall numerous telephone calls and in-person conversations with Gil, where he informed me that he was not comfortable with Ross as his attorney. I told Ross early on that there was a conflict of interest given the aforementioned legal representations and relationships. I then directed an associate, Megan Beauregard, to perform legal research on the ethical issues involving conflicts of interest. Following our research, I concluded that a material conflict of interest existed and that we needed to disclose the same to the client. At the time, I did not know, but would soon learn from my associate conducting the legal research, that Ross, too, had been represented by Tober in cases involving ethical and legal malpractice violations. Given the above, I prepared a motion to disqualify Tober as attorney for Mr. Gil's wife in the divorce. The basis of the motion was the aforementioned conflicts of interest, the overall impropriety, and the potential significant compromise of the client's interest in a hotly contested divorce. I had countless discussions with Ross regarding the issues of the conflicts and argued strenuously that we move forward on the motion. On several occasions, I asked Ross why he would not permit me to simply talk to the client about the conflicts issues, especially since I had come to learn that Ross, too, had been represented by Tober. I could not understand why Ross was so insistent in his refusal to seek to disqualify Tober. I became so frustrated and distraught over these issues that I began to confide in several people close to me about the ethical dilemma. Specifically, I talked to Megan Beauregard, as well as my then-current husband and even a relative, all with the single goal of trying to find out why a senior partner at my firm would block the disclosure of a conflict of interest. Up until this point in time, I had only the highest regard for Ross. I worked extremely hard on his cases and felt fortunate to work with him. Gil was unaware of the conflicts of interest relating to Tober's prior representation of me, Ross, and Wiggin and Norrie. However, from the inception of Tober's involvement, Gil was uneasy with having Tober involved in the divorce because just prior to Tober's appearance, the records of a therapist, Dr. Broussard, went mysteriously missing while Gil's wife was represented by attorneys Rona Wise and Matthew Kozel. As I mentioned, in December of 2007, Gil became uneasy with Ross as his attorney. Gil expressed concern that a plan existed between Ross and Tober to bill the divorce case excessively. Gil was concerned that Ross did not want to have any contact with him. On numerous occasions, I continued to inform Ross that Gil was uneasy with Tober's involvement and was likewise uneasy with Ross's representation of him. I implored Ross to speak with Gil regarding Gil's concerns. However, Ross did not want to deal with the issue of whether a conflict existed by virtue of Tober's involvement, and Ross would not speak with Gil. In Ross's opinion, no conflicts of interest existed by virtue of Tober's involvement. Ross never discussed with me the subject of Tober's prior representation of him. Again, I could not understand why Ross seemed to be fighting not to move to disqualify Tober. During this time period, the global economic crisis had begun, and there were numerous in-firm discussions about rainmaking and billing clients. It became clear to me that I was being set up for something, and that if anything went wrong with the divorce, I would be blamed. Indeed, I knew that eventually the aforementioned conflicts of interest would lead to real problems with the client. I informed Tober of the motion, and it was clear that he was troubled by it. For example, at a court hearing following having advised Tober of the motion, Tober appeared to be trying to intimidate me by standing uncomfortably close to me, scowling, and generally looking threatening. I also began to realize that Ross's behavior in litigation style became unusual. For example, Ross informed me that if and when Sarah Gill's deposition would go forward, he would aggressively explore incidents of sexual abuse she suffered in her past. Doing so, however, would not advance the interest of Gill nor be relevant to any issues in the case. It was also out of Ross's character to engage in such lines of inquiry. It then became obvious to me that this line of inquiry would only be used to delay the litigation by forcing Tober to stop the deposition. Indeed, Ross was so committed to preventing the deposition of Sarah Gill in order to allow the extremely lucrative, approximately $100,000 per month case to continue, that he told me that Sarah Gill would never sit for a deposition. Ross said that either Ross or Tober would feign a heart attack or some other medical problem in order to stop the deposition. Ross told me multiple times that Sarah Gill's deposition was simply not going to happen. Meanwhile, it seemed as though every effort I made to advance the case was being thwarted. For example, I tried for many months to secure the deposition of the opposing party, Sarah Gill. Yet, when I would discuss this with Ross, he seemed unconcerned that we were unable to secure the deposition. Likewise, as discussed below, Ross was unconcerned and uninterested in the mysterious unavailability of Dr. Broussard's records. While Ross and I had worked closely together for years, there was now obviously sharp tension between us, and he was beginning to communicate less with me. I began to believe that Tober and Ross were in constant communication and were conspiring to frustrate the case from being advanced to closure. During this time frame, Wiggin and Norrie's financial challenges became more acute. For example, there were no bonuses distributed at the end of 2008, and the litigation activity in the firm had declined precipitously. The firm had many meetings regarding its financial challenges and the economic slowdown generally in the legal profession during this economic recession. As the case continued, it became clear to me that anything concerning the case which I would tell Ross would soon be learned by Tober. I concluded that Ross was not representing the best interest of the client, but instead was acting in collaboration with Tober to continue the case and continue the sizable monthly legal fees being paid by Gill. Despite all the fees and my best efforts, depositions had been blocked or thwarted, and other depositions, such as Sarah Gill's, as noted above, surely would not take place under Ross's watch. I no longer trusted Ross. I stayed out of the office as much as possible. Occasionally, Ross would call me and inquire about the case. His most common question was to inquire about the client's current thinking. Through my conduct in the case, I began to make it clear to Ross that I would not be a party to what I saw as unethical conduct, and this created greater distance between me and Ross. Eventually, this friction was expressed in an email response that I had sent to Ross. He had asked me, in an email, to engage in some ethically questionable conduct, and I responded that I would not do it. By this point, I was close to leaving the firm. I did express to Ross the client's displeasure with the case, the lack of depositions, and other related issues. I informed Ross that the client wanted to interview other law firms. I soon interviewed William Levine of Lee & Levine in Boston, Massachusetts, as potential successor counsel to Wiggin and Norrie. I explained to Levine that depositions had not been conducted, that discovery efforts were being thwarted by Tober without resistance from Ross, and that we had not obtained the therapy records of Sarah Gill. I said that I needed to find successor counsel who could properly represent Gill's interests. I also informed Levine about Ross's conflict given Tober's involvement and Ross's apparent efforts to force the expensive case to continue by delaying necessary proceedings, among other things. They listened to what I had to say and agreed to a second meeting. After listening intently to the challenges I was facing in representing Gill, Levine advised me that the situation would not likely end well with Wiggin and Norrie. He then gave me the name of another lawyer with an expertise in ethics. That lawyer, who also listened intently as to what I had to say, advised me to leave the law firm of Wiggin and Norrie. As for the therapy records of Sarah Gill, they had been in custody of her therapist, Dr. Broussard. At various times, Dr. Broussard's office had represented that the records didn't exist due to 1, a water and flood problem, 2, a fire, and 3, an accidental shredding by Dr. Broussard's secretary. Broussard's office even stated that the records might be in storage. Ross rejected my efforts to challenge in court these suspect and inconsistent grounds for allegedly not having medical records. I came to the conclusion that Dr. Broussard's records may not, in fact, have been destroyed, given my review of the records of Dr. Garber, which note that he reviewed Dr. Broussard's records in which detail a conversation Dr. Garber had with Dr. Broussard, wherein Dr. Broussard acknowledges the existence of the records. From time to time I had heard Ross make highly derogatory comments about Gill. This was unusual, as he typically did not make such comments about his own clients. Later in the case, as I began to understand what was happening between Ross and Tober, I reflected upon the fact that Ross strongly encouraged me to communicate with Tober by telephone rather than in writing, even insisting that I do so even though every phone conversation I had with Tober would subsequently be misrepresented by Tober, leading to follow-up letters, disputes, delay, and more legal fees. For this reason, I had long preferred to communicate with Tober in writing so as to eliminate such unnecessary work and delay. Ross never explained to me his rationale for why I should only communicate with Tober via telephone and not in writing. At some point toward the very end of my relationship with Wigan and Norrie, I told Ross that I know what's going on here. I recall making a statement along the lines of, "How much money do you need?" I gave my notice to Wigan and Norrie, advising them that I would be leaving the firm.